सर ऑडिबल किससे होने सर? आया ऑडिबल किससे हो?
Good morning.
Good morning, sir.
Good
Good
morning,
morning,
sir.
sir.
Good morning.
Very good morning. Am I audible to everybody?
Yes, sir.
Okay.
Yes, sir.
Just a minute. I am putting. Is the PPT visible?
Yes, sir.
Yes, sir.
Okay. Okay. Let's start with today we'll discuss Sales of Goods Act 1930. Okay, so let us discuss what are the things we'll particularly discuss in today's class. First is the contract of sale, then conditions and warranty, then transfer of ownership, performance of the contract, and unpaid sellers and his rights. Okay, so these are the few aspects today we'll discuss. So let us understand first what is a contract of sale. A contract of sale means what? There is a definition which is given by the Blackstone. Uh, According to its definition, when one person transfers the ownership of a goods to another in consideration of a price, a sale is have to be made. And this again has been defined by the section 4, subsection 1 of your Sales of Goods Act. A contract of sales of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to buy for a certain price. That means here you see, in order to make a contract of a sale, there must be two parties. First, buyer, second, the seller. Okay, there must be two parties. And there must be a contract between the two parties for the purpose of a transfer of ownership of goods for a certain price. This is the entire what contract of sale. But generally, what is happening? Sometimes we are making a mistake whenever we are considering both the things as same. That is a sale and an agreement to sell. A sale is a contract of sale, whereas an agreement to sell is not a contract of sale. Right? That means you are agreeing with another to make a sale in the future. That is what agreement to sell. But a sale means it is a contract of sale, whereby one party transfers the goods to another party or the possession of the goods to the another party for a price. Is that clear? Now you understand what is a sale or contract of sale and what is agreement to sell.
Yes, sir.
Okay. So let us go a little bit deeper into these terms so that we'll able to understand. Let us, if we'll understand what are the essential characteristics of a contract of sale, then we'll a little bit more able to understand in depth. So let us discuss the characteristic of the contract of sale. The first characteristic is that there should be a valid contract. That means as the contract of sale is a contract itself, that is why all the essential elements of a valid contract must be satisfied, like valid offer, valid acceptance, free consent, capacity of the parties, and valid or lawful consideration, and parties must be competent to contract. And the object should be also lawful. So these are the essential elements of a valid contract. All these essential elements should be present. If any of these essential elements will be absent, then the contract of sale cannot be made. Right? Second point is that there must be at least two parties. That means a sale has to be a bilateral contract because the property in the goods to pass from one person to another. The seller and the buyer must be different persons. A person cannot buy his own goods. As you know, that a person cannot buy his own goods, right? So able to understand the second point, that is two parties. And the third point is agreement for transfer of ownership. Agreement for transfer of ownership means it is essential to transfer the general property in the goods from the seller to the buyer with or without physical possession of the goods. You see, sometimes what goods are in such a stage that its physical possession is difficult to be transferred. But the ownership of the goods or the title of the goods is to be transferred immediately so as to give effect to a contract of sale. Is that right?
Yes, sir.
Okay. Another essential element is that there must be some goods. If it will be Sales of Goods Act, that means goods must be there. The subject matter of the contract of sale must be goods. The property which is it to be transferred from the seller to the buyer. If there will be no goods, then there will be no contract of sale. Right? And the last but not the least, that is the price. To constitute a valid contract of sale, the consideration for transfer must be money paid or promised. That means whatever the amount is to be paid as a purchase consideration, that is in the monetary terms. It will be not any other benefit, right? So it must be what a money paid or money promised to be paid. That shall constitute the consideration for the Sales of a Goods Act. Now you understand in detail actually what is the sales of a goods.
Yes, sir.
Okay, so uh, what is the agreement to sell? That also I have made you understand.
Yes.
Let us understand what are the distinctions between your sell and agreement to sell. Of course, I think the slide is a little bit hazy and it will not be visible to you clearly, or it is visible clearly.
Yes, sir.
Yes, sir.
Okay.
Okay.
So let us
Yes,
discuss.
sir, visible.
Okay, right. As I thought that it is a dark color, so that I thought that it may or may not be visible to you. Okay. Anyway, it is visible. It's good. These are the few points of a distinction between sale and agreement to sell. First thing is the nature of the contract, if you want. Then sales is an executed contract, whereas agreement to sell is executory contract. So executed contract and executory contract I have made you understand earlier or not?
Sir, executor contract means?
Executed contract means a contract in which both the parties had fulfilled their obligations. Their respective obligations they have fulfilled. That is what an executed contract. Whereas executory contract is a contract in which the obligation of the parties are yet to be completed. That means both the parties to the contract that they have not fulfilled their obligations to the contract. Right? Able to understand?
Yes.
In a sales, what is
Yes.
happened? It is an executed contract. Why? Because one party has transferred the ownership of the goods to another, and another party has paid the amount for that. That means both the parties have fulfilled their legal obligations. As a result, it is an executed contract. Whereas in agreement to sell, that means the sale will be made in the future and the price will also be made in the future. That means the entire contract is your executory. Is that right?
Yes.
Okay. Now, second thing is the transfer of a property. Uh, in a sale, the transfer of a property from the seller to buyer transfers immediately. Whereas in the agreement to sell, the property also transfers from seller to buyer, but it will be at a future date, right? Presently, nothing will be moved. And third point of distinction is regarding your risk of loss. Here you see in a contract of sale, as ownership passes immediately to the buyer, that is why the risk of loss is that of the buyer. Whereas in agreement to sell, the risk of loss is entirely falls on the seller. Why? Because the property in the goods has not been passed by the seller to the buyer. Am I audible?
Yes, sir. Yes, sir.
Very good. So let us understand what are the consequences of the breach. Consequences of the breach means if any party fails to fulfill his own part of obligation. Here you see the buyer what may sue for delivery of the goods or for damage to the what if it is a contract of sale, then the buyer may sue for delivery of the goods for the damage or for damage, and in the agreement to sell, if the buyer fails to accept the goods, the seller may sue for the damage only. Now you understand the things are reversed here. In a sale, the buyer may sue for delivery of the goods or damage. Why? Because he had already paid the goods. But if the seller has not delivered the goods in the right time or right quantity or right quality, then the other party, that means the buyer, can file a suit for the delivery of goods or for the damages. Whereas in a in an agreement to sell, what happens? Here you see the buyer, if the buyer fails to accept the goods, then the seller may sue for the damage. Okay, damage only, not for the goods. So next point is the insolvency of the buyer. Insolvency, you know? What do you mean by insolvency? Yes, anyone can tell?
Insolvency means, sir, when the organization goes to bankruptcy.
Not the organization, any person. Any person can also become bankrupt. So
Bankruptcy.
whenever a person or any organization becomes incapable of paying its debts, then it will be declared as insolvent.
Insolvency.
So there are consequences. You see either the seller or the buyer, both the parties can become insolvent. So let us see what are the consequences. If the insolvency of the buyer, the seller is bound to deliver the goods to the official receiver of the buyer. But in case of agreement to sell, the seller may not part with the goods until he is paid for, because you see in an agreement to sell, the payment has not yet been made. There is only agreement to sell. That is why the seller is not bound to part with the goods until he is paid for. But here, what is happening? In case of a contract of sale, the seller is bound to deliver the goods to the official receiver of the buyer. Is that right?
Either DA.
Okay. You see, whenever the buyer becomes the insolvent, when the buyer becomes insolvent, if it is agreement to sell, that means the seller has not been paid. So until the seller has been paid, he may not part with the goods, right? But the seller is bound to deliver the goods to the official receiver of the buyer. Official receiver means after declaration of insolvency, then the official receiver shall be appointed by the by the order of the court, and that official receiver shall receive all the claims against the person and settle all the claims against the person. Right? Able to understand this? The next point is the insolvency of the seller. If the seller will become insolvent, then what will happen? Here, the buyer is entitled to what? Recover the goods from the official receiver of the assignee. Okay. That means the buyer is, as the buyer has already paid the amount, that is why the buyer is entitled to recover the goods from the official receiver of the seller, right? But in case of agreement to sell, the buyer can claim only what a rateable dividend and not the what goods, because the property in the goods is not yet passed to him, right? In case of the insolvency of the seller, and if it is a contract of sale, then the buyer is entitled to recover the goods from the official receiver of the seller. But in case of agreement to sell, the buyer can claim only rateable dividend. That means proportional due to his loss.
अरे
Whatever.
gross
Yes,
धारतो क्या कर दो
Sorry, there is some disturbances in the class.
sorry sir sorry
Please mute yourself. Okay. So the next point is a right to resell. If it is a contract of sale, the seller cannot resell the goods. But if it is an agreement to sell, then the seller may sell the goods since the ownership is with the seller. And regarding the right of usage of the goods, the buyer has a right to use the goods he buys, and here you see in an agreement to sell, it does not give the buyer the right to use the goods, क्योंकि buyer के पास तो goods अभी पहुंचा नहीं है, उसका ownership भी transfer नहीं हुआ है, so how he can use it, right? So these are the few distinctions between your sale and agreement to sell.
Sir,
Is
right
any-
to sell, the seller
Yes.
cannot sell the goods in case of sale.
Because why? Because the property of the goods already transferred to another person. So he
Okay,
is not the legal owner. Although the goods are in his possession, he is not the legal owner of the goods. So how can he How can he use the good, or how can he resell the goods? He cannot.
Yes, yes.
But
Okay.
sir,
Yes.
sir, suppose I have made a agreement to sell contract with you. You are selling a property to me, and I will have to pay the amount within 2 months. Let's
Yes.
say you are selling a property and I am buying that property, and the property value is 2 lakh. I have to pay in 2 months, right? So there is an agreement to sell contract between you and me. And in the meantime, suppose I have paid 1 lakh in 1 month, and next month I have supposed to pay 1 lakh more. But in the meantime, how can you sell the property to some other party?
Okay. Okay.
The seller may sell the goods since ownership is with him. But you have
Okay,
made a contract with me, and I
Okay.
have
Don't be
paid 1 lakh with
impatient.
you. Yes.
Just don't be impatient. We are going to that. Actually, after a few discussions, then we will reach there. That is, what is the duties and rights of an unpaid seller. Okay. At that time, we'll discuss regarding that. Don't worry about that. We'll discuss later on. Okay. Let us continue. Now we'll discuss another concept. That is your conditions and warranties. So generally, whenever we are purchasing or selling the goods, there must be certain conditions. So what do we mean by the condition? तो condition का मतलब क्या होता है? The conditions actually these are the stipulations. Actually, condition. Yes. Facing any difficulty? You I'm not audible clearly.
Sir, condition means proposal or promise, whatever given by seller and buyer.
Okay. But if you will go through the law, then you will find little bit water twisted. And what is the meaning of this condition? The term condition which is defined under section 12, subsection 2 of the Sales of Goods Act 1930 as a requirement that is necessary to the contract's fundamental purpose. That means it is one important point basing upon which the contract is made, and on failure of this point, the contract will be water repudiated. Right? A stipulation essential to the main purpose of the contract, the breach of which gives the right to treat the contract as repudiated. इसका मतलब क्या हुआ? If you have made a contract to purchase a Maruti car from the Maruti Suzuki car from the showroom, but finally whenever you got the car, you find that HM engine has been fitted to that Hindustan Motors car. So that is a what? That is a what condition? Essential condition to the main purpose of the contract. क्योंकि आपने मारुति का और मारुति सुजुकी का कार परचेज किया है, तो उसमें मारुति सुजुकी का ही इंजन होना चाहिए, ना कि उसमें आपका कोई हिंदुस्तान मोटर्स का इंजन होना चाहिए. This is a what? It is a stipulation which is essential to the main purpose of the contract.
What do you mean by repudiated?
Repudiated means rejected. Okay. इसका
Contract being
मतलब
paid.
हाँ, इसका मतलब क्या हो रहा है? ये जो कॉन्ट्रैक्ट हो रहा है, इस कॉन्ट्रैक्ट में कोई ऐसा एक पॉइंट हो रहा है, इंपॉर्टेंट पॉइंट, एंड ऑन नॉन फुलफिलमेंट ऑफ दिस इंपॉर्टेंट पॉइंट द पार्टी कैन रिजेक्ट द कॉन्ट्रैक्ट. This is called your conditions. Okay, just I am giving you a few examples so that from them you will able to understand. If the buyer expressly mentions that goods should be delivered before stipulated date, then date will be taken as a condition, right? If the buyer expressly mentions that goods should be delivered before a stipulated date, then the date will be taken as a condition, as a buyer expressly mentioned it at the time of a contract. Now I am giving another example. Ramson consults Samsung, a motor car dealer, for a car suitable for touring purposes to promote the sales of his product. And Samsung suggests Maruti 800 car. And accordingly, what Ramson buys it from Samsung. The car turns out to be unfit for touring purpose. Here the term that the car should be suitable for touring purpose is a condition of the contract. And as this condition has not been fulfilled, so Ramson can repudiate the contract. That means can reject the contract. Is that right? समझ में आ रहा है?
Yes, yes.
Yes, sir.
Yes, sir. Yes, sir.
Very good. Now we will discuss regarding the warranty. What is warranty? Warranty, which is also defined under section 12, subsection 3 of Sales of Goods Act 1930 as a stipulation collateral to the main purpose of the contract. That means it is not the main purpose of the contract. It is not directly affects the main purpose of the contract, but it is collateral to the main purpose of the contract, the breach of which gives rise to claim for damage, but not the right to reject the goods and treat the contract as repudiated. इसका मतलब क्या हो रहा है? ये जो वारंटी होता है, ये भी एक कंडीशन होता है, but it is it is collateral to the main purpose of the contract. Main purpose of the contract के लिए कुछ नहीं है. That means it is related to any ancillary. और जैसे कि होता है, just I am giving you an example.
Supplementary.
हाँ. So Rajesh buy a new Maruti car from showroom, and the car is guaranteed against any manufacturing defects under normal uses for a period of 1 year from the date of original purchase. And the event of a manufacturing defect, there is a warranty. That means if there will be any manufacturing defect within that period, then it is under warranty, and now the Maruti company is responsible for replacement of a defective part if it cannot be properly repaired. If it will be properly repaired, then it will repaired. Otherwise, it will be replaced. Okay. But after the period, during जो period आपको दिया गया था 1 year या 6 months तो कुछ दिया गया था, उसके बाद अगर कुछ defect भी आता है तो उसके लिए no one is responsible. You are supposed to make the repair at your own cost. और यहाँ पर क्या हो रहा है, आप कार ले आए परचेज करके और अभी कोई 6 महीने के बाद कोई छोटा मोटा डिफेक्ट दिया तो आप उसको लेकर जाओगे शोरूम में और दे विल रिपेयर इट, और इसके लिए तो आप रिजेक्ट नहीं करोगे कि भाई आपने मुझे गाड़ी परचेज किया था, आपने मुझे खटारा दे दिया, अभी मैं रिजेक्ट कर रहा हूँ इसको। ऐसा नहीं हो सकता। समझ में आ रहा है? क्योंकि ये जो मैकेनिकल डिफेक्ट या टेक्निकल डिफेक्ट या मैन्युफैक्चरिंग डिफेक्ट, छोटा मोटा मैन्युफैक्चरिंग जो डिफेक्ट होता है, these are what are not to what concerned with the main purpose of the contract. These are ancillary. Okay, these are collateral to the main purpose of the contract, for which you can claim for damage. Yes, suppose if you are suffering certain losses or certain damages for that, you can claim for that, but you cannot reject the offer. Okay, or you cannot reject the contract, entire contract you cannot repudiate. Okay, able to understand? A warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives rise to a claim for damages, but not to a right to reject the goods and treat the contract as repudiated. That means the party cannot repudiate the contract. Is that clear?
Yes, sir.
Okay. Now let us understand a few distinctions between the
सर इसमें से गारंटी वाली कुछ है क्या? गारंटी या वारंटी?
ये वारंटी ये कंडीशंस एंड वारंटी डिस्कशन कर रहा है। गारंटी है बट दैट गारंटी विल डिस्कस लेटर ऑन। ये गारंटी कहाँ आएगा?
ओके,
ये कहाँ आएगा बताओ? किसी उसका हेडिंग कुछ होगा?
Guarantee means a complete replacement.
नहीं, एक्चुअली देखो यहाँ पर क्या, वारंटी पीरियड में अगर कोई डिफेक्ट होता है तो वो डिफेक्ट भी रिप्लेस होगा। अगर वो पार्ट नहीं मिला, रिपेयर नहीं हो सकता है तो वो भी कंप्लीटली रिप्लेसमेंट होगा। तो वारंटी का मतलब क्या होता है? टू जो डिफेक्ट है वो डिफेक्ट को आपका सॉल्व करने के लिए, तो डिफेक्ट को सॉल्व करने के लिए क्या किया जा सकता है? रिपेयर किया जा सकता है, और अगर रिपेयर नहीं हो सकता है तो रिप्लेस करना जरूरी है, तो रिप्लेस भी किया जाएगा। ये आ रहा है आपका वारंटी में। तो गारंटी का कॉन्ट्रैक्ट में जो गारंटी होता है, इट इज अ डिफरेंट एस्पेक्ट दैट विल रीड इन डिफरेंट चैप्टर। ओके, दैट इज अनदर चैप्टर। गारंटी और एक चैप्टर है, ठीक है। अभी हम डिस्कशन कर रहे हैं कंडीशंस एंड वारंटी। तो कंडीशंस एंड वारंटी में जैसे कि डेफिनेशंस में बताया गया कि कंडीशन क्या होता है? रिक्वायरमेंट और इवेंट दैट शुड बी परफॉर्म्ड बिफोर द कंप्लीशन ऑफ अनदर एक्शन, एंड दैट इज नोन एज ए कंडीशन। एंड वारंटी में क्या होता है? ए वारंटी इज एन अश्योरेंस गिवन बाय द सेलर टू द बायर अबाउट द स्टेट ऑफ द प्रोडक्ट दैट द प्रिस्क्राइब्ड फैक्ट आर जेन्युइन। इसका मतलब क्या हो रहा है कि ये सब जितना फैक्ट है, ये सारा फैक्ट जेन्युइन है और उसको हम मेंटेन कर रहे हैं। वारंटी वही होता है। ओके, एंड रिगार्डिंग डिफाइनिंग सेक्शन, कंडीशन डिफाइन होता है बाय द सेक्शन 12 सबसेक्शन 2 ऑफ इंडियन सेल्स ऑफ गुड्स एक्ट, whereas warranty has been defined under section 12 subsection 3 of Indian Sales of Goods Act. And regarding association, you see it is directly the condition is directly associated with the main object of the contract, whereas warranty is a subsidiary provision related to the object of the contract. और violation में क्या होगा? तो violation of a condition can be regarded as a violation of the warranty. देखो, अगर violation of a condition हुआ तो इसका मतलब क्या हुआ? It is also regarded as a violation of the warranty. लेकिन violation of a warranty does not affect the condition. Right? Violation of warranty does not affect the condition. And the consequence क्या होगा? अगर ये हो रहा है कंडीशन का ब्रेच हो रहा है तो क्या होगा कंसिक्वेंस ऑफ अ ब्रेच? रिपुटेशन ऑफ अ कॉन्ट्रैक्ट और टर्मिनेशन ऑफ द कॉन्ट्रैक्ट और रिजेक्शन ऑफ द कॉन्ट्रैक्ट. और वारंटी में क्या होगा? यू कैन फाइल ओनली फॉर द डैमेजेस, claim damages for the breach. And regarding the remedy available, the parties can repudiate the contract as well as a claim damage. Where? In case of a condition, failure of the condition, the party can repudiate the contract as well as claim for the damage. But in a warranty, the remedy available to the aggrieved party for the breach of the warranty, he can file or he can claim only damages, nothing else. Is that clear, all the points I have discussed?
Yes, sir.
Yes, sir.
Or facing any difficulty in your understanding?
No, sir.
Okay, so let us go ahead. Okay, few essential points also I have written here for the conditions and warranty, which I should discuss first, but as I have discussed the distinction, so I think all the points you have understood. Here essential conditions. Conditions का क्या essentials है? First, it is essential to the main purpose of the contract. Second, the non-fulfillment of the condition causes irreparable damage to the aggrieved party, which would defeat the very purpose for which the contract is made. And the breach of condition gives the right to the aggrieved party to resign the contract and recover the damages for breach of contract. तो उसमें क्या क्या possibility आ सकता है? First thing, it is essential to the main purpose of the contract. Okay. And second thing, इसका अगर fulfillment नहीं हुआ कोई condition का, it causes irreparable damage to the aggrieved party, which would defeat the very purpose of the contract. इसका मतलब contract का जो main purpose होता है वो defeat हो जाता है. अगर defeat होता है तो क्या हो सकता है? Remedy उसका क्या हो सकता है कि breach of condition gives right to the aggrieved party to resign the contract and recover the damage for the breach of condition. तो यहाँ दो चीज हो सकता है, एक तो होगा resign the contract, another he can also recover the damage for the breach. And in the essential elements of your warranty, it is a collateral to the main purpose of the contract, and the breach of a warranty causes damage to the aggrieved party and does not defeat the main purpose of the contract. So the aggrieved party can only claim damages for breach of warranty, but cannot repudiate the contract. Is that clear?
So purpose slide essentials of.
Okay. Yes.
Okay, sir.
Okay. Now we'll discuss regarding what are the different modes of a delivery. So generally, what in a sale contract of sale we understand that is delivery of a goods. But what is the exact meaning of a delivery, and how for the legal purpose we understand the delivery of the goods has been made? For this purpose, actually we have find out the classification of a delivery. There are three types of a delivery. First one is your actual delivery, second one is a symbolic delivery, and third one is your fictitious delivery. Okay, actual delivery, symbolic delivery, and a fictitious delivery. So what is the actual delivery? That is a physical delivery of the goods takes place when the goods are physically handed over by the seller or his agent to the buyer. It is coming under section 33. That means it is a very simple, that a physical delivery of the goods takes place when the goods are physically handed over by the seller or his agent to the buyer, right? Next one is your symbolic delivery. Symbolic delivery means when the goods are incapable of actual delivery due to its nature. For example, if you want to purchase a ship, okay, जो समुद्र में जाने वाला शिप है, ठीक है, तो if you wanted to purchase a ship, then whenever you want to purchase it, the seller will hand over this ship to you. Can hand over? No, because
No.
it's the nature of the goods that it cannot be delivered. So what it can deliver? If there will be any key, or if there will be any ownership title to the ownership of the goods, then that can be transferred. Document of the title of the goods that constitute delivery. Okay, suppose delivering the key of a warehouse where the goods are stored. Suppose you have a huge amount of cabbage you have stored in a warehouse which you wanted to sell, and when there is a sale made, you have received the money and you have handed over the key of that good what a warehouse. That is what a symbolic delivery. इसका मतलब delivery of the goods हुआ, but due to the physical nature of the goods you cannot deliver the actual goods, but you have transferred them in such a way that the other person becomes the owner. ये हो गया आपका symbolic delivery. It is little bit difficult than the what physical delivery. Now the last part, that is what constructive delivery. Constructive delivery, which I told you, fictitious delivery. Okay, so when delivery is made without any change in the actual possession of the goods, it is known as a fictitious delivery. Means it is deemed to take place in the following situations. ये जो होता है आपका fictitious delivery या constructive delivery, उसको बताते हैं कि constructive delivery. So these happen in three situations. Situation 1, where the seller in possession of the goods agrees to hold them on behalf of the buyer after the sale. समझ में आ रहा है? इसका मतलब seller is in the possession of the goods and agrees to hold them on behalf of the buyer after the sale. कभी कभी ऐसा होता है ना, बाजार में जब आप खरीदते हो उसको पैसा दे देते हो और सारा चीज बैग में डाल देते हो और उसको बताते हो कि भाई ये बैग आपके पास रहा, जब मैं लौटूंगा तो इसको ले जाऊंगा. That means the goods are in the possession of the seller, and after the sale, the seller also agreed with you to retain the goods. Second one, where the buyer is in possession of the goods before the sale, and the seller agrees to buyer holding the goods as owner. अभी इसका मतलब क्या हो रहा है? Where the buyer is in possession of the goods before the sale and the seller agrees to the buyer holding the goods as owner. अभी सपोज आपका एक दोस्त कोई आपका बाइक लिया है, ठीक है, आपका बाइक लिया है टू मेक ट्रायल, और वो ट्रायल कर दिया, देखा कि हाँ ठीक ठाक है, तो आपको बोला भाई मैं ले लेता हूँ, तो आप एग्रीमेंट साइन करोगे सेल के लिए. तो इसका मतलब सेल से पहले बाइक उसके पास और सेल के बाद भी बाइक उसके पास. ये हो गया कंस्ट्रक्टिव डिलीवरी. एंड थर्ड, where a third party like a warehouse man who was holding the goods as a belly of the seller and agrees after the sale to hold them as a belly of the buyer. इसका मतलब क्या है? अभी जो वेयर हाउस में आप गुड्स डाले हैं, वो वेयर हाउस का एक कीपर होता है, वेयर हाउस मैन उसको बताते हैं, ठीक है. So whenever you are keeping your goods in the that warehouse, that means the warehouse keeper or warehouse man is acted as a belly of the seller. So after the sale, the warehouse man is ready to act as a belly of the buyer. That means there is no movement of the goods. There is no physical movement of the goods or actual movement of the goods. यहाँ पर physical movements नहीं हुआ, ownership पे कुछ नहीं हुआ, लेकिन क्या हो रहा है? Sale हो गया. Okay, so without wherever there is no actual movement of the goods, then this type of transfer of the goods or delivery are called your constructive delivery or fictitious delivery. Is that clear?
Point number 2 थोड़ा.
Point number 2, where the buyer is in possession of the goods before the sale and the seller agrees to the buyer holding the goods as owner. इसका मतलब क्या है? मैं बता दिया था अभी. सपोज आपका कोई दोस्त आपका बाइक लिया है, ठीक है, आपका बाइक लिया है, उसको बाइक अच्छा लगा, उसने आपको फोन में पूछा कि भाई मैं ये बाइक खरीदना चाहता हूं. आप बोले ठीक है, 50,000 मुझे दे दो. तो गेव यू 50,000 रुपीज. लेकिन अभी पैसा देने से पहले उसको गुड्स हैंड ओवर हुआ, लेकिन अब आप जो सेल कर रहे हो उसको, तो अभी तो गुड्स तो आपके पोजीशन में नहीं है, ठीक है. Where the buyer is in possession, यहाँ देखो बायर पोजीशन ऑफ गुड्स में है, अभी सेलर के पास गुड्स नहीं है. एंड द सेलर एग्रीज टू द बायर होल्डिंग द गुड्स एज ओनर. इसका मतलब जो गुड्स उसके पास है अभी था, लेकिन उसका ओनरशिप आपका था, लेकिन सेल हो गया तो ओनरशिप चला गया, लेकिन गुड्स उसके पास पहले से डिलीवर हो गया था.
Right.
Okay.
Okay.
Yes.
So now we will discuss the important aspect which actually someone of you have asked regarding the unpaid seller. Unpaid seller का मतलब क्या होता है? A person who has sold goods to another person but has not been paid for the goods or has been paid partially is called an unpaid seller. जो एग्जाम्पल आपने दिया था कि कोई सेल के लिए आपने एग्रीमेंट किया था और उसका
sir.
पार्टली पेमेंट आया था.
Yes, sir. I have.
तो अगर पार्टली पेमेंट भी आए तो वो अनपेड सेलर हो गया, ठीक है.
Hmm.
A person who has sold goods to another person but has not been paid for the goods or has been paid partially is called an unpaid seller, right?
Right.
और ये जो डेफिनेशन जो सेक्शन 45 का सबसेक्शन 1 of Sales of Goods Act, it also defines the unpaid seller as one who has not been paid the whole of the price of the goods or has supplied or has been partially paid for the goods. ओके, इसका मतलब जो गुड्स सप्लाई हुआ उसके लिए वो पेमेंट बिल्कुल नहीं किया या पार्टली किया. और क्या हो सकता है? Who has been given a negotiable instrument like a bills of exchange that has been received as a conditional payment and the condition on which it was received has not been fulfilled by reasons of designer of the instrument. इसका मतलब क्या होगा? अभी सपोज आप एक मारुति कार खरीद लिए शोरूम से और उसको एक चेक दे दिए, ठीक है, और वो चेक डिजाइनर हो गया, तो जो मारुति शोरूम वाले बन गए क्या? ऑन पेड सेलर. समझ में आ गए? तो अनपेड सेलर क्या हो सकता है? आइदर नॉट पेड एट ऑल और पार्टली पेड, और इफ पेड थ्रू एनी ऑफ द बिल्स ऑफ एक्सचेंज and the bills of exchange is degenerate, then the seller becomes unpaid seller. तो ये unpaid seller का क्या होता है? राइट्स देखेंगे. तो unpaid seller का राइट्स होता है against the goods and against the buyer, ठीक है. तो against the goods क्या हो सकता है? When the property in the goods has passed. अगर प्रॉपर्टी गुड्स का जो पास हो गया है तो क्या कर सकता है? राइट ऑफ लिएन. इसका मतलब गुड्स रख सकता है, प्रॉपर्टी ट्रांसफर हो गया, ओनरशिप ट्रांसफर हो गया, लेकिन अभी तक गुड्स है उसके पोजीशन में, देन ही कैन यूज द राइट ऑफ लिएन. इसका मतलब गुड्स को डिटेन करेगा जब तक उसको पैसा नहीं मिलता. ओके. और क्या कर सकता है? राइट ऑफ स्टॉपेज ऑफ गुड्स इन ट्रांजिट. अगर ये ट्रांजिट
right of lien means
राइट ऑफ लिएन मीन्स राइट ऑफ डिटेंशन of the goods. till the payment is made.
Okay.
ठीक है. और सेकंड वाला रहा राइट ऑफ
That
स्टॉपेज.
is, sir, ownership.
Yes, ownership.
Lien is ownership, sir.
The right of a lien, that means to detain the possession of the goods. क्योंकि अभी when the property in the goods has been passed, property in the goods already pass हो गया है, ownership transfer हो गया है, ठीक है. तो अब क्या कर सकते हो आप, उसको डिटेन कर सकते हो. राइट ऑफ लियन प्रॉपर्टी जो गुड्स है, जो इसका मतलब जो फिजिकल पोजेशन है, फिजिकल पोजेशन यू हैव टू रिटेन, दैट इज व्हाट राइट ऑफ लियन. ठीक है. सेकंड वाला रहा राइट ऑफ स्टॉपेज ऑफ गुड्स इन ट्रांजिट. स्टॉपेज ऑफ गुड्स इन ट्रांजिट का मतलब क्या हो रहा है? सो इफ द गुड्स आर इन ट्रांजिट, अब प्रॉपर्टी भी ट्रांसफर हो गया, अब गुड्स ट्रांजिट में है, तो द पार्टी हैज आल्सो द राइट टू स्टॉपेज ऑफ द गुड्स इन ट्रांजिट. और थर्ड थिंग क्या आ रहा है? राइट ऑफ रीसेल. अब क्या करेगा, अगर पैसा नहीं मिल रहा है तो ये सेल भी कर सकता है. राइट ऑफ रीसेल. अब समझ में आ गया आपका जो क्वेश्चन था? आपका जो क्वेश्चन था
Yes, sir.
कि
Yes,
मैंने पार्ट पेमेंट किया था, अब क्या कर सकता है? अगर आपने 2 महीना दिया था, 2 महीने के टाइम के अंदर अंदर आपके बाकी पैसा नहीं दिए, तो क्या कर सकता है?
He has the right to sell the property. Yes.
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 Okay.
Yes, sir.
And the second
Sir,
thing, when the property in the goods has not passed. हाँ हाँ.
ସେ ଯୋଉ ରିସେଲ ଯଦି କରିବ ତାର ଯେତିକି ପେମେଣ୍ଟ ପାର୍ଟଲି କରିଥିବ ଏଟା ତ ଫେରି ଦବ ତ?
କାହିଁ କରିବ? ଫେରେଇବ କାହିଁକି?
Not necessary.
Not necessary.
Okay, sir.
Why? Because you have failed in your commitment.
But yes, sir, there must be a clause of right to reserve that amount, no?
You see, if there will be any clause, then it's okay. If there will be no clause, then what will happen?
So he has
Whether
the
he
right to
will
forfeit. So he has the
right
right
to
to
retain
forfeit
the-
the amount.
right to forfeit. Right to
Forfeit the
forfeit.
amount, no? Yes.
Yes, yes. But if there will be any clause in the contract regarding the refund of the advance amount, at that time it is called advance amount.
Mm.
Okay. But if there will be no contract to the contrary, then the party can forfeit the.
Forfeit the amount, yes.
Yes, yes. Now we'll discuss when the property in the goods has not passed. इसका मतलब क्या होता है? Goods भी डिलीवरी नहीं हुआ और प्रॉपर्टी भी उसका ट्रांसफर नहीं हुआ. That means the entire thing is with the seller. तो ये क्या कर सकता है? First, तो यहाँ पर क्या होगा? He can totally both the things are there when property in the goods has not passed. इसका मतलब क्या हो रहा है? उसके पास टोटली गुड्स भी है, उसका प्रॉपर्टी भी है. So that what will happen?
He can sue the seller. I mean, he has the right to sue the seller.
Who have the seller? No, I am now discussing what are the particularly rights of an unpaid seller.
Yes.
So if we are discussing regarding the rights of an unpaid seller, तो इसका मतलब हो रहा है कि जो सेल हुआ है उसका प्रोसीडिंग्स उसको नहीं मिला, लेकिन वो प्रॉपर्टी भी आपको ट्रांसफर नहीं हुआ, और क्या हुआ कि उसके पास भी ओनरशिप भी है. ठीक है, ओनरशिप है एंड द पोजीशन ऑफ द गुड्स दोनों है. दोनों है तो क्या करेगा वो?
For withholding delivery.
Yes, he can withhold the delivery of the goods. He can resell the goods.
Stoppage in transit.
यहाँ पर स्टॉपेज क्या, ट्रांजिट में तो गुड्स नहीं है ना, बिकॉज द गुड्स आर इन हिज पोजीशन. तो स्टॉपेज ऑफ गुड्स इन ट्रांजिट जरूरी नहीं है.
सर रीसेल भी तो कर सकता है.
हाँ, यहाँ पर क्या कर सकता है? एक तो डिटेंशन ऑफ द गुड्स, दूसरा रहा आपका राइट ऑफ रीसेल. समझ में आ रहा है?
Yes, sir. Yes, sir.
Yes.
Okay. Now we will discuss the rights of unpaid seller against the buyer of the goods. ये तो against the goods था. अभी against the buyer क्या कर सकता है? यहाँ पर पहला वाला होता है right to sue for price. अगर unpaid seller है तो वो प्राइस के लिए sue कर सकता है. Second, right to sue for damage. उसका कुछ जो डैमेज हो रहा है because of what not receiving the price, he can also file that. Then right to sue for interest. So if there will be any clause for that, suppose there in the contract of sale, if the payment is not received within 15 days, then the interest at the rate of 10% shall be chargeable. If there will be a clause, then the unpaid seller has the right to sue for interest, and the unpaid seller has the right to repudiation of the contract before the due date. समझ में आ रहा है? Repudiation of the contract before the due date. Due date से पहले repudiation of contract के लिए उसके पास भी right है unpaid seller का.
Sir, right to sue price means?
Right to sue for price. इसका मतलब जितना पैसा देने के लिए बताया गया था, सपोज पार्ट पेमेंट किया है तो बाकी पैसा देने के लिए अगर इन टाइम नहीं दिया तो उसके लिए
वो प्राइस बढ़ा सकता है?
नहीं, प्राइस बढ़ाएगा नहीं, जितना प्राइस था
The remaining amount.
वही प्राइस. अगर
Other
बिल्कुल
remaining
पेड नहीं हुआ है तो एंटायर प्राइस के लिए, अगर पार्टली पेड हुआ है तो रेस्ट प्राइस के लिए he can sue.
Okay.
सेकंड थिंग,
Okay.
ये जो टाइमली पेमेंट नहीं हुआ उसके लिए उसका कुछ डैमेज हुआ अगर, उसके लिए भी वो स्यू कर सकता है. थर्ड थिंग क्या हुआ, अगर कुछ कंडीशन होगा कि वहां पर इफ द पेमेंट हैज नॉट बीन रिसीव्ड विद इन 15 डेज, इंटरेस्ट एट द रेट ऑफ 10% और 12% इज चार्जेबल, तो अभी उसको भी और एक क्लॉज मिल गया, तो राइट टू स्यू फॉर इंटरेस्ट. ओके, और क्या कर सकता है? रिपुडिएशन ऑफ अ कॉन्ट्रैक्ट बिफोर द ड्यू डेट.
सर ये तो सेक्शन सर
यस
सर ये सेक्शन 45 में ये सब रूल रेगुलेशन है, बट हम लोग भी अलग से कुछ कंडीशन डाल सकते हैं इसमें?
हाँ, अभी जो जब आप कंट्रैक्ट ऑफ सेल करते हो, अगर आप एक्सप्रेस कॉन्ट्रैक्ट करते हो, रिटन कॉन्ट्रैक्ट करते हो, तो एट द टाइम यू कैन मेंशन द कॉन्ट्रैक्ट एंड मेंशन द टर्म, एंड बोथ द पार्टीज इफ दे एग्री टू द टर्म देन इट्स ओके.
ओके सर, ओके.
Right?
Yes,
So
sir.
then there is a concept, I think you can read and understand it, that is concept of doctrine of a kept emptor. इसका मतलब क्या होता है? ये एक लैटिन वर्ड से आया which means let the buyer beware. इसका मतलब क्या होता है कि जो बायर है, द बायर को बहुत कुछ जानता है, बायर को कुछ बताने का जरूरी नहीं है. ये जो आपका डॉक्ट्रिन है, इसका मतलब होता है कि बायर इज एन एजुकेटेड पर्सन एंड ही नोज एवरीथिंग. इट इज नॉट द ड्यूटी ऑफ द सेलर टू डिटेल टेल एवरीथिंग टू द बायर. ओके, that means it is no part of the seller's duty to point out the defects of the goods which he offers for sale. Rather, it is the duty of the buyer to satisfy himself about the quality as well as the suitability of the goods. That means the person who
सर इसमें
buys
से
the
ये
goods,
लिख सकता है जो
हाँ.
सब्जेक्ट टू टर्म्स एंड कंडीशन करके छोड़ देगा अगर.
हाँ, वही होता है. जो टर्म्स कंडीशन को आपको जानना बहुत जरूरी होता है. टर्म्स कंडीशन से आप बिना जाने जो साइन कर देते हो वही हो जाता है डिफिकल्टी.
हाँ वही तो बात है सर, वो लिख देगा छोड़ देगा, छोटा करके लिख देगा सब्जेक्ट.
इसका मतलब क्या होता है?
ସେଟା actually ଯେ 50% ଲେଖୁଛନ୍ତି ଅଫ୍ ଲେଖୁଛନ୍ତି या ଛୋଟ ଛୋଟ କରି ଅପ୍ ଟୁ ଲେଖୁଛନ୍ତି, ପଇସାରେ ଅସୁବିଧା କରୁଛି.
एक्चुअली दीज आर पॉलिसीज. अभी ये बिजनेस पॉलिसी होता है, बिजनेस स्ट्रैटेजी होता है. इसको समझने के लिए आपको चौकन्ना होना चाहिए. एवरीवेयर दे आर पुटिंग टर्म्स एंड कंडीशंस, सब्जेक्ट टू टर्म्स एंड कंडीशंस. तो पहले हमें जानना जरूरी है, जो कि पहले जानना चाहिए कि टर्म्स एंड कंडीशंस क्या है. ओके, बट टू दिस doctrine there are a few exceptions. Okay, so what are the exceptions? First is the fitness of a product for the buyer. इसका मतलब क्या हो रहा है? अगर ये जो बायर होता है ये सेलर को बता दिए कि भाई ये जो मेरे लिए ऐसा प्रोडक्ट चाहिए, मुझे ऐसा प्रोडक्ट दो। तो अकॉर्डिंग टू द रिक्वायरमेंट ऑफ द बायर, व्हेन द सेलर गिवन हिम सम अदर गुड्स, देन यहाँ पर क्या होता है, सेलर्स का रिस्पॉन्सिबिलिटी आ जाता है। समझ में आ रहा है? अभी सपोज मैं गया एक दुकान में, भाई मैं बोला मुझे आप एक काम करो, 50 वाट का एक बल्ब दो, ठीक है, 50 वाट का। लेकिन वो क्या क्या, वो मुझे एक 5 वाट का बल्ब दिया। तो मैंने नहीं देखा कि या उस गुड्स पर कहीं पर नहीं लिखा है वाटेज क्या है, लेकिन फाइनली व्हेनेवर आई हैव यूज्ड दैट वन, आई फाउंड इट इज ऑफ 5 वाट। तो मैं पहले उसको बोल चुका हूँ कि मुझे 50 वाट का बल्ब चाहिए, तो 50 वाट के जगह पर वो 5 वाट का दिया। तो अभी अगर मैं बताऊंगा उसको, तो उसको रिटर्न करना जरूरी है और 50 वाट का देना होगा। अगर नहीं दे रहा है तो आई कैन फाइल सूट अगेंस्ट हिम। समझ में आ गया? सेकंड आ गया क्या, गुड्स परचेज अंडर ब्रांड नेम। तो गुड्स परचेज अंडर ब्रांड नेम का मतलब क्या हुआ, आप दुकान में गए और बोले कि भाई मुझे रूपा का बनियान चाहिए, तो रूपा का बनियान दिया। लेकिन आप 2 दिन यूज करने के बाद आपका बनियान खराब हो गया, तो आप जाओगे दुकान में, भाई क्या मैंने आपको बताया था बनियान दो, बनियान 2 दिन में खराब हो गया। अरे वो बोला आपने तो भाई रूपा का ये बोला है, हमने तो रूपा का चीज दिया है आपको, हमने तो कोई दूसरा कंपनी का चीज नहीं दिया ना, आपको रूपा का दिया है। तो वहां पर उसका कुछ राइट, ये कुछ नहीं बनता, सेलर्स का कुछ ओब्लिगेशन नहीं बनता। ओके, when the buyer buys a product under a trade name or branded product, the seller cannot be held responsible for the usefulness or quality of the product. So there is no implied condition that the goods will be paid for the purpose the buyer intended. समझ में आ गया? थर्ड क्या हो रहा है, गुड्स सोल्ड बाय डिस्क्रिप्शन। अगर गुड्स, when the buyer buys the goods based only on the description, there will be an exception. If the goods do not match the description, the seller will be responsible for the discrepancy. इसका मतलब क्या हो रहा है, आप एक कार परचेज किए हो, ठीक है, तो कार में जो सब कंडीशंस जो होता है, डिस्क्रिप्शन, सारा डिस्क्रिप्शन में लिखा होता है ना, वो डिस्क्रिप्शन में लिखा हुआ है कि 4 व्हील्स डिस्क ब्रेक। लेकिन फाइनली जब आपने व्हीकल खरीदा, तो खरीदने के बाद आप देखे कि उसका जो डिस्क ब्रेक है वो 2 व्हील में फिटेड है और 2 व्हील में आपका डिस्क ब्रेक नहीं है। तो यहाँ पर क्या हुआ, गुड्स बाय डिस्क्रिप्शन, इसका मतलब डिस्क्राइब किया गया है गुड्स का, और गुड्स अगर डिस्क्रिप्शन को मैच नहीं करता है, द सेलर विल बी रेस्पॉन्सिबल फॉर द डिस्क्रिपेंसी। यहाँ सेलर का लायबिलिटी हो जाता है।
सर ଆମେ ଯେତେବେଳେ କିଣିବୁ ଆମେ କଣ ସବୁ ଡେସ୍କ୍ରିପସନ କୁ ଜାଣିପାରିବୁ, କିଛିଟା ଜାଣିପାରିବୁ?
ତମେ ଡେସ୍କ୍ରିପସନ ଟା ଜାଣିପାରିବନି ଯେ, କିନ୍ତୁ ଯାହା ଡେସ୍କ୍ରିପସନ ସେ ଲେଖିକି ଦେଇଛି, ତମେ ଯେତେବେଳେ ଗୁଡ୍ସ ଟା ଆଣିଛ, ଇଟ୍ ଇଜ ଆଜ୍ୟୁମ୍ଡ ଦ୍ୟାଟ୍ ଯେ ଗୁଡ୍ସ ରେ ସେଇ ସବୁ ଡେସ୍କ୍ରିପସନ ଥିବ। ତାର ଅର୍ଥ ଯଦି ତମେ ଇନ୍ ଫ୍ୟୁଚର ୟୁ ଫାଇଣ୍ଡ ଆଉଟ୍ that some description was not there, it is not possible for a layman to understand all the technical descriptions. तो जो डिस्क्रिप्शन आपने वो लिख कर दिए हैं कि ये सारा डिस्क्रिप्शन रहेगा गुड्स का, अगर बाद में आप परचेज करने के बाद देख रहे हो कि इसमें ये डिस्क्रिप्शन नहीं है बिल्कुल, तो यहाँ पर द सेलर इज रिस्पॉन्सिबल। व्हाई? बिकॉज इट इज नॉट मैचिंग द डिस्क्रिप्शन। आपको जो सेल किया है डिस्क्रिप्शन में, वो डिस्क्रिप्शन को मैच करना जरूरी है। डिस्क्रिप्शन अगर मैच नहीं होगा तो द सेलर विल बी रिस्पॉन्सिबल फॉर द डिस्क्रिपेंसी। ओके, नेक्स्ट थिंग, गुड्स ऑफ अ मर्चेंटेबल क्वालिटी। यहाँ पर क्या होता है, द एक्सेप्शन ऑफ अ मर्चेंटेबल क्वालिटी इज डेल्ट विथ इन द सेक्शन 16 सबसेक्शन 2, एंड अकॉर्डिंग टू दिस सेक्शन a seller selling products by description has an obligation to provide items of a merchantable quality. तो जब गुड्स बाय डिस्क्रिप्शन वो सेल करते हैं, वो गुड्स मर्चेंटेबल क्वालिटी होना चाहिए, मार्केट का क्वालिटी होना चाहिए। दैट मीन्स गुड्स दैट कैन पास मार्केट रिक्वायरमेंट। और मार्केटेबल अगर नहीं है तो मर्चेंटेबल क्वालिटी नहीं है। आपको बोल दिया भाई हमने आपको व्हीकल देंगे, लेकिन व्हीकल मार्केटेबल नहीं, तो हियर द Seller is responsible for that. Okay. और बाकी एक दो पॉइंट रहे, दो ही पॉइंट रहे, टाइम हो गया। नेक्स्ट इज सेल बाय सैंपल। तो जहां पर सेल होता है बाय सैंपल, इसका मतलब क्या हुआ कि आप जब गए दुकान में, सपोज एक राइस का जो होलसेलर होते हैं, तो उसके पास आप गए, बोले भाई मुझे बासमती राइस चाहिए, तो आपको एक सैंपल दिखा दिया। वो सैंपल में देखे कि वो जो राइस है वो बड़ा बड़ा राइस है और उसका एक अच्छा खुशबू आता है, तो सैंपल के हिसाब से आपका चॉइस हो गया और आप पैसा दे दिए 100 किलो के लिए। लेकिन वो जो बाद में भेजा आपके पास, वो जो पैकेट भेजा, तो पैकेट जब खुला आपने देखा कि ये राइस अलग क्वालिटी का है, वही स्मेल नहीं आता है और वो उसका लेंथ भी छोटा छोटा है। तो अगर ये सैंपल मैच नहीं करता, जो सैंपल आपको दिखाया था वही सैंपल को आपने रखा था और अभी जो गुड्स आपने खरीदा वो सैंपल के साथ मैच नहीं करता है। इफ द गुड्स नेवर मैचेस टू द सैंपल, देन द रिस्पॉन्सिबिलिटी ऑफ अ सेलर arises there. Okay. And a sale by description and sample. If a product is sold based on the sample and description, the buyer is not liable. If the product does not match the sample or description, the vendor will be entirely responsible for that. Another point is trade usage. Trade usage में क्या होता है? There is an implied condition or warranty on the quality or suitability of the goods or product. However, if the seller deviates from this, the kept emptor principle no longer appears. That means अगर जो ट्रेड यूसेज होता है, ट्रेड का मतलब क्या होता है? जैसे कि आपका मार्केटेबल क्वालिटी होता है और जो प्राइस होता है, आपको सपोज प्राइस पता नहीं है, आपको अगर प्राइस पता नहीं है और वो मार्केट का जो प्राइस होता है, प्राइस का 4 गुना प्राइस ले लिया है, तो इट इज अगेंस्ट ट्रेड यूसेज। तो फॉर दैट द सेलर इज रिस्पॉन्सिबल। ऐसा नहीं कि आप जो जिसका प्राइस 500 रुपीज वो 2000 चार्ज करेगा। हाँ, एक्स्ट्रा चार्ज कर सकता है, 510 रुपया 100-200 रुपया चार्ज कर सकता है एज ए प्रॉफिट, लेकिन कोई तो 4 गुना तो प्रॉफिट नहीं ले सकता है ना, 3 गुना प्रॉफिट नहीं ले सकता। ओके। एंड द लास्ट पॉइंट इज योर फ्रॉड और मिस प्रेजेंटेशन। अगर मिस रिप्रेजेंटेशन हुआ या कोई फ्रॉड हुआ, and by the fraud or misrepresentation the seller sold the goods, then the doctrine जो kept emptor, it will not apply. Here the vendor or the seller is held responsible for all the legal consequences. And regarding the important questions, these are the important questions. Discuss the essentials of a valid contract of sale in detail. What do you mean by the term sale and the agreement for sale? Also differentiate the two terms. Then discuss the conditions and the warranties implied by law in a contract for the sale of a good. Okay, so these are the important questions, and I think the time is already over. So thank you so much for being present in the class. Thank you so much. I am leaving the class.
Thank you, sir.
Thank
Thank you,
you.
sir.
Thank you, sir.
Thank you, sir. Have a good day.
Okay, thank you.
Thank you, sir.
Okay, sir.
Okay, thank you. Upulu. ଟିକେ ବନ୍ଦ କରିଦେଲୁ ରେ ବନ୍ଦ କରିଦେଲୁ ନାଇଁ ମୁଁ ଆଉ ଗାଧେଇବିନି ମୁଁ ଯିବି ଏଠି ଲିଭ୍ ମିଟିଂ
End to all ମାରିଦିଅ।
ହ୍ୟାଲୋ
ସାର୍ end to all କରିଦିଅନ୍ତୁ କଟିଯିବ total।
end to all